Hi, everybody. I'm Monty McIntyre. I'm the publisher of California Case Summaries. I'm a mediator, arbitrator, referee with ADR Services, and I do what I call master lawyer mentoring, training lawyers to become trial lawyers and associates to become great lawyers. And I also have a podcast called Trial Alchemy on Spotify and Apple, where I interview great plaintiff and defense members of ABOTA who are outstanding trial lawyers about trying their cases. Now, this week I'm going to be talking about a case in the Code of Civil Procedure. Uh, many cases in California were not going to have any attorney's fees recoverability. For example, if you don't have a contract clause or if there's no statutory clause that gives you attorney's fees. And in these cases, one of the things that attorneys should always consider is using requests for admissions under the Discovery Code, because under 2033, what you're going to have is there's a section where if you send a request for admissions, and if the other party denies the admissions, and if you ultimately prove these admissions at trial, then, except for certain limited exceptions, you can get a recovery of attorney's fees from the court, and that can be very powerful. Now, what's interesting about this section, it's been in the Discovery Code for a long time, but for many years, nobody ever used it. In fact, about 10 years ago, I had a case where I was representing a party in a breach of oral contract case, and I told the client, look, we can't get attorney's fees, but we're going to send out requests for admissions, and if the other side denies them, which I think they will, we may be able to get attorney's fees that way. Unfortunately, the trial court, even though we won a trial, got everything we asked for, and even though they denied the admission, which most attorneys do on lots of requests for admission, the trial judge at that time, about 10 years ago, said, no, I'm not going to give attorney's fees, blah, blah, blah. I don't think they had a reasonable basis for denying the request that we sent, but the trial court used that. Now, what you're going to see in this case summary that you can read below is there's a recent decision that was published in October of this year, 2023, and the court talks about recovering attorney's fees for the refusal to admit requests for admissions. And in this case, you'll see, take a look at the way the court talks about it, because I think this is exhibiting a shift in thinking in terms of our Superior Court judges. And this is something that can be a very helpful, powerful tool for attorneys if they're trying to give their client an opportunity to recover fees if you have to go to trial in cases where you can't get attorney's fees otherwise. So take a look at the decision. I think you'll find it of value, and I think you'll find it very interesting. And whenever you need a mediator or an arbitrator or a referee who knows California law, I'd love to help you through ADR Services where I work. If you want to keep up easily with the new case law in your practice areas to give you an advantage over your opponents and help you win more cases, then you can subscribe to an individual subscription of my California case summaries. And I also offer law firms a great unlimited user subscription option where if the law firm has really more than 5 lawyers, it's a great price, and the more lawyers you have in the firm, the better the value is. So take a look at those things. Listen to my podcast, Trial Alchemy, if you want to learn how to try cases from some of the trial masters. And I hope that you find this information be helpful. If you want to get some training on how to become a great trial lawyer, or if you have young associates who need to be trained to become effective lawyers for your law firm, feel free to contact me. I hope I serve you and help you with this. And until we meet again, do well and be well. Bye-bye now.